I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are discussing the current state of data protection law in the Asia Pacific region. There is a lot going on in the data world, and so it's often difficult to keep track of what is happening globally on issues like privacy, cybersecurity, incident response, and AI. To make it even more complicated, there are so many countries in the Asia Pacific region leaning into the regulation of data and technology. As a result, it's hard for any team or single individual to keep track of all of those developments. I am happy to report that we have you covered here on the Data Chronicles with an Asia Pacific update, including where we have been and where's the current enforcement trends and where the region is headed into the future. To discuss, I've invited my partner, Charmian Aw, to the podcast. Charmian is a partner in our Singapore office and leads much of our multi-jurisdictional work across the Asia Pacific region. Charmian, welcome to the podcast.
Thanks so much, Scott.
So, I think, Charmian, I think many of our clients and many of our listeners want to give an understanding of really what's happening across Asia Pac. There's obviously so much that's happening at a local country level that it's sometimes difficult to track. And it's even more difficult to try to bring all of those new developments into your global compliance program. So maybe give us a sense of where are the hotspots right now inside of Asia Pac? Which countries are pushing forward their data protection laws? Where do we see new data protection laws coming up? And where do you see that going over the course of 2025?
Great question. So I'd like to start off with maybe a bit of a geographical kind of mapping of, Asia and APAC in particular. We have North Asia where, there are very significant markets like China, South Korea, Japan, even Taiwan. They are all looking at not just amending and refining existing requirements around things like cross-border data transfers and, the processing of personal data, but even non-personal data and AI. And then when you look at South Asia, which spans, all the way from India to even Australia and New Zealand, which is part of APAC, right? Because Asia Pacific, there is so much activity going on as well. I think we all can agree that India, which is the most populous nation in the world at the moment, they have already passed Digital Personal Data Protection Act. They're waiting for the announcement as to when this DPDPA will take effect. And, that will really kind of like set the scene for data privacy in a very significant market and certainly in a very significant business process outsourcing hub for the region. And then moving more, I suppose, towards the east, when we think about the geography, we like to call this region that I'm actually based in. I'm based in Singapore, and Singapore is sometimes seen as a bit of a node to Southeast Asia. So we are talking about 10 member states within ASEAN, right? The Association of Southeast Asian Nations. There is so much activity going on. Indonesia has its law in place. They're looking to pass a set of implementing regulations. It was supposed to happen last year, but didn't, so it might happen this year. Vietnam has, made headlines with regards to the enactment of a new personal data protection law, which is much more extensive than the earlier personal protection decree, or PDPD for short. So we are all waiting with bated breath on that particular new law in Vietnam, which is exacerbated by the fact that I think an announcement was made that they have shortened the timeline for this law to be implemented from October this year to May this year. So we are only looking at 2 months before this new personal data protection law in Vietnam is going to take effect. And I think, other very significant jurisdictions that continue to ramp up enforcement would include Thailand, the Philippines, and Singapore. Malaysia is another very significant Southeast Asian market that just amended its act, which was initially enacted in 2010, and the first batch of changes took effect in January this year. So happy to talk through some of the specifics around Malaysia's amended PDPA. But again, right, we are seeing so much activity just in that 10 member state block. So I'm going to pause there and see if there were any sort of areas that I could provide further insight into.
Charmian, I mean, that's really helpful overview. And, my guess is we could probably do an episode on every single one of those countries to finally to go in and in the details of what has been happening. I think one of the things that we've certainly have seen in the United States is a lot of interest around China and Hong Kong. Obviously, the geopolitics is driving a lot of that, and some new rules that are taking into a place from the Department of Justice that would restrict transfers of U.S. data to China, to Hong Kong, and to other countries of concern. So maybe just pause for a moment again, just kind of it's happening in China itself. Where do you see the development of the PIPL and the implementation of PIPL together with kind of some of the cybersecurity oriented terms? Because that ends up being a key area of focus within the Asia Pac region.
That's a great question. I think with China, they had a bit of a journey in terms of where they are now with cross-border transfers, right? So data originating from China, transferring overseas, and they don't really make a distinction as to the destination, right? The recipient jurisdiction. There isn't a white or a blacklist approach per se. But what they've done is they've prescribed a list of, I would say, thresholds and requirements, which if triggered, right, would compel you to actually either file a security assessment with their authority, which is called the Cyberspace Administration Authority of China. And that magic number for a security assessment to be filed is 1 million in one calendar year. So starting from 1st January in a year, if you are actually processing 1 million or more personal data sets, right, or unique personal data subjects data, you need to file this security assessment. The next magic number with China is 100,000, again in one calendar year. So that is the number in relation to when you need to execute what they call the standard contractual clauses or the standard contract. And that is a very rigid and prescriptive form. It is quite unlike the EU SECs. And for those of us who are familiar with ASEAN or the Southeast Asian nations, we also have our voluntary set of model contractual clauses for cross-border transfers. But China's SECs are very prescriptive and you cannot modify these terms. So it's, you have to minimally include all of the provisions. You can, on a case-by-case basis, include additional provisions, but you certainly cannot take away or delete provisions in the standard form. So 100,000 and more, which, by the way, is not a massive number for certain, certainly many of our global clients and global multinationals. I think it's a low threshold, right? And certainly for China, it's a drop in the ocean. And I wanted to maybe just extend this point about numerical thresholds. Unlike some of the other major laws we're seeing, for example, in the US and in Europe, Asia has this tendency to lean into a numerical number. For example, right? So I talked about Malaysia, right, amending its law. They have this mandatory data protection officer requirement, but that is only going to be triggered if you process more than 20,000 individuals' data or the sensitive personal data of 10,000 or more data subjects. So again, it's a very hard number. It's a very bright line approach to this concept of when you actually have to appoint a DPO. Same thing with Singapore. Not many people know this, but our breach reporting requirements actually contain a very hard number of 500, which is very, very tiny if you think about the grand scheme of things and populations around the world. But it's all contextual, right, Scott? So, Singapore has a population of 6 million, so 500 seems to make sense because it is of a significant scale for at least, Singapore homegrown organizations processing personal data onshore. So when you cross that number, you actually have to report any kind of a breach to the regulator. So in some sense, this hard number sometimes poses a certain level of compliance in Asia that is unique to these markets and certainly not seen, in other parts of the world.
Yeah, it's really interesting. And, in some ways you can find a corollary for those who are in the United States where you have a data breach notification statutes, oftentimes that will be triggered based on a number of people, and that will trigger notification primarily not to the individual, but to the regulators or to law enforcement in the event that it topples over a specific set of a numerical threshold. But to your point, right, it's the same kind of thing where you're looking at a state population and that's going to be smaller than the national population. So just maybe continuing on that theme, Charmian, it's almost difficult to get your arms around what is happening within the entire region when you necessarily need to be looking at what is happening at the individual country state level. And as a result, it's not something where you can say, okay, what are the laws in Asia Pac, which is usually a question that we often get. And as if it's one kind of set of laws, and we all know that it's many. So now maybe the key question, if I'm trying to think about trend lines, where do you see those big kind of sweeping areas of concern? Where do you see the trends happening in terms of any thematic developments? I think you mentioned, as we were in a different context, you mentioned that the lawful basis for processing is one of them. And that may differ than how the EU has approached things.
That's a great question, Scott. And again, very unique to Asia. Consent is very much at the front and center of these laws, at least initially. So what I mean by that is if you track, for example, Singapore's Personal Data Protection Act, which came into force 2012, full force 2014, and then sort of looking at the premise of how you would process personal data under the Act, it was very much consent-centric. So you needed to have obtained consent to process personal data, even though there was this concept of deemed consent. So it's by conduct, right? Not so much by sort of opt-in written agreement. But if you fast forward to 2020, when we had a massive amendment of the law to keep up to date with certainly developments in Europe and the GDPR, we introduced legitimate interest. We introduced this unique exception to consent, which is known as the business improvement exception. And I think ultimately Asia is on a journey. There is an evolution of Asia data privacy laws and data laws, initially looking at consent as the sole legal basis. So, to give you some examples, currently there is no legitimate interest as a basis for processing in China, in India, and in Vietnam, right? So currently it's still very much looking at consent. There are others that also recognize deemed consent, though, like, the Philippines, Thailand, Taiwan, and Brunei. But I think, we will have to watch this space very closely because it may be that there will be an evolution where later on down the line, we are seeing the trickling in of more exceptions and more lawful basis for processing in Asia.
And then, I think another thing, Charmian, that you have told me about in the past is that one another unique issue that is thematic is some of the local language requirements that may appear, whether that be in your privacy notices that would need to be placed, your consents. Can you talk a little bit about what those requirements look like and what the challenges are to try to meet those requirements?
Yeah, I think that's also a really great question, very topical. And to preface that, I think the question always arises as to whether a particular law applies, right? So, am I bound by Vietnam's, personal data protection decree, soon to be personal data protection law, if I'm processing Vietnamese residents' data, say in the US? And the answer will surprise a lot of people not familiar with APAC, but the answer is yes. So there is actually this extension of the applicability of a lot of Asia data privacy laws into residency. So, Indonesia, Vietnam, and the Philippines, for example, regardless of whether the processing is done within those markets, the laws actually apply. So if you are processing, say, an Indonesian citizen's data offshore, you could still be subject to Indonesia's law. And so assuming that the law applies, then you'll need to cater for local language requirements. And how does that translate to operational compliance for global MNCs, right? It goes down to, your privacy policies having to be in a local language. So in Indonesia, it's Bahasa Indonesia. In Malaysia, it's Bahasa Melayu. In India, we all know it's 22 gazetted languages in India, no more, no less. And in Vietnam as well. So you actually have to provide these notices and these policies in the local language. And, like I said, it's a bit of a trend because when we look at Malaysia's amendment to the law, right, just this year, even the DPO needs to be proficient. That's the word, proficient, in not just English, but also in Bahasa Melayu. And the DPO needs to be resident in Malaysia. So we're starting to see these sorts of local language requirements trickle in across the spectrum of obligations.
And it sounds like DPO residency requirements, what I think would also be a challenge
Exactly.
for global organizations.
Exactly.
So if I'm thinking, about one of the other topics you raised, Charmian, which was around data breach notification and the small threshold that would be where you could hit that in Singapore, as you and I both know, oftentimes when we are dealing with incidents now, almost all of them have a global nature. Attackers are able to not only compromise data that is specific to Singapore or specific to the United States, but instead it covers people around the world, and that is for no other reason than companies are global themselves and they have operations around the world. And so even if there is an attack on a Singapore server or a US server, it tends to impact people around the world. And that can be a real challenge for trying to manage data breach notifications, statutes, and obligations. And so I'm interested in your perspective. Where do you see the cyber portion or the breach notification portion of things developing in Asia Pac?
Unfortunately, the answer seems to be that there is much more divergence than there is convergence. And what I mean by that is, I don't think that there is a one size fits all approach to breach reporting, certainly not in this part of the world. And the requirements tend to be hyper localized. It's not just a numerical thresholds, it's about how do you define a data breach? Are there exclusions? And how do you define, the sort of reporting standards? So, every regulator has its own standard form, becomes not so standard. Because when you're dealing with, say a breach that involves, 10 jurisdictions in Asia, and sometimes, again, understanding that there's a different form with sometimes word count limits for each is all very time sensitive, and you really need to have a strategy that is that you have in place ahead of the incident. So, and I think it's really also understanding that now that so many jurisdictions in Asia have data privacy laws, have cybersecurity reporting requirements, and it is a patchwork because even aside from the comprehensive data laws that require breach reporting, insofar as personal data is compromised or implicated, you also have sectoral regulators that have been in the space for a very long time. And if clients are in a regulated sector or regulated industry, you are basically dealing with a noodle bowl of requirements, and you have to really respond very, very quickly and know, be very quick on your feet because and also strategically, I think one of the things that we constantly hear from clients is, it seems like, for example, in Europe, we find ourselves in a situation where we're able to not have to report. Is there really a need to report in, say, certain markets in Asia? And I get the concern because if you think about it, once you report to one regulator, there is no guarantee that it doesn't, go out there and report. Regulators are certainly working in these, even if it's not formal cooperation type, arrangements. They do a lot of information sharing, and certainly if you have to report, say, to data subjects, then it really is out there. So I think you have to start thinking about, data breach and cybersecurity reporting as a bit of a strategic risk management kind of exercise, and with Asia as part of the agenda because it's no longer a region that we can kind of ignore or kind of deprioritize given the level of activity that we're seeing.
Yeah, and maybe adding on to that, Charmian, is that it sounds like you need to have a good handle on what operations you have in each of these countries before an incident happens. In other words, trying to learn about what data you have after the fact is usually an area where things go wrong, and it sounds like that's true now in Asia Pac as well.
Exactly. One of the key markets that we were all, waiting with bated breath when they passed their DPDPA is India. And, India has a very interesting kind of exemption around foreign data. Again, to your point about sort of, having a good handle right? It's certainly not one size fits all. And in fact, we urge clients and I guess companies that we work with to really look at Asia again strategically, understand how to in a way structure your group activities, your intercompany agreements, to take advantage of some of the unique nuances provided by Asia data protection laws. For example, with India, with the foreign data exemption, you might want to, in a way, map, right, your processing activities and ring fence activities relating to foreign data that's processed within India versus the domestic data, meaning the Indian data subjects data. And you can do that via, your intra-group agreements. You can certainly do that in assessments and so on and so forth, your policies. But it's to really look at it through the lens of every single market has its unique nuances. And how do I really map, right, a strategy around Asia using these nuances?
Yeah, I mean, and I think obviously this can feel overwhelming to, many organizations who are looking to try to manage these issues. And so a typical question we would get is, all right, so there's a lot of obligations. Where do you see the specific maybe areas of enforcement, both in countries and then in topics?
Yeah, great question. I think there is already a very clear sign when you read a law that there are certain things that they're really looking for, accountability, which is a very general term that encompasses everything from, making sure you have appointed a data protection officer, you have a policy that adheres to and incorporates the obligations you're subject to, either as a controller or processor. In the case of Australia, there's no distinction with regards to the local laws. I think gone are the days when you can just kind of copy and paste a EU SEC's type agreement and change the names of the parties. I think they need to see some demonstration that you have actually considered the local requirements and you have really, in a way, tailored your documentation around that. But I think, just to take it further down the line, Asia actually has, funnily enough, a lot of laws in Asia have this personal liability, potential for personal liability in relation to non-compliance with data laws. We see Korea, India, Indonesia, and the Philippines, for example, right? Just a sampling of jurisdictions where there are potential liabilities for personal, either data protection officers or directors and people responsible for the processing of data. And I think that that's something also to bear in mind when thinking about the level of compliance and how much you want to really invest in ensuring that your compliance program for those markets is robust and in place.
Yeah, well, that would probably be alarming to many if there's an opportunity
Exactly.
for personal liability. I mean, I guess, Charmian, if as you're working with clients to get their arms around how to try to manage to the developments in the space and to manage their risk in the area, I think many of our clients look for global solutions
Yes.
to these problems. Any practice points that you would want to share about how to manage to local law compliance, but at a global level?
I think you've actually just hit the nail on the head, Scott. It's really taking a very global commercial view of it, which is why I think you were moving away from data compliance, right, to data strategy, because we do need to understand that at the end of the behind the scenes with regards to compliance is a business that's operating across different markets, across different geographies, and data is actually borderless with regards to how they actually transfer data between their offices, but also really understanding that you do need to at least customize and have a very bespoke approach when it comes to certain pain points. Asia has its own, Europe has its own, and the US has its own, and there's also Latin America and the Africa. So it's really understanding that it is a global company, but the solutions need to be sufficient to withstand the local kind of regulatory scrutiny as well.
Yep. And that is a puzzle that I think probably the two of us spend our time, most of our days trying to figure out. Well, Charmian, I really appreciate the overview and the insights on what's happening within Asia Pac. I'm sure we're going to have many opportunities to share with our audience developments in the space, and we'll have an opportunity to do deeper dives into some of the things that are happening within individual countries and throughout the region. So, but in the meantime, I really appreciate the overview, which has been so helpful to kind of get a sense of where we currently stand and perhaps where we expect to go.
Likewise, looking forward to it. And thanks so much, Scott, for having me on.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.